My name is Savvas Daginis, and I focus on Canadian and US business, technology, and privacy law. I'm going to discuss everyone's favorite topic, data protection agreements. Specifically, what are they, and as a business, should I have them? Generally, your business signs data protection agreements with third parties when you are providing important data to those third parties. When I say data, I'm referring to three types of data: confidential and proprietary data, personal data, as in personal information, and any other data that you believe is worth protecting that's crucial to your business. Data protection agreements typically cover three general specific concepts: data protection, data privacy, and data security. Data protection covers the preservation of data and your ability to access the data. Think of the data's availability to you. Data privacy covers the proper use and disclosure of data, and in the case of personal data, giving individuals control over how their data is accessed, used, or even shared across borders. Data security covers the safeguarding of data against unauthorized access, use, or destruction through the implementation of appropriate technical and organizational measures. Think security controls. You may ask, how specific and complicated does my data protection agreement have to be? The answer to this is, unfortunately, it depends. It depends on two factors. To what extent do you, as a business, want to control the protection, privacy, and security of your data in the third party's hands? And what does the law say? In regards to the first, if you are using the third-party service to store your crucial data and you won't be also keeping the data on your own servers, then you want to be sure that such data is preserved and available for your use, that it is not improperly disclosed to others, and that the third party has implemented appropriate security measures to prevent unauthorized access, use, or destruction. As an example, say your book of business is not saved on your business servers, but rather stored in the cloud, as in the servers owned by a third party. You want to be confident that your data will be preserved and that it will nearly always be available for your access. In addition, you don't want your competitors to be able to access your book of business, so you want to ensure that the third party doesn't share the data with your competitor and protects your data from unauthorized access with safeguards such as requiring you to log in to access your data, or even encrypting the data while it's at rest in their servers or in transit to you. Your book of business may also constitute personal data, and so you may also need to ensure that the third party abides by privacy laws. The specificity and robustness of your data protection agreement is also determined by which laws apply. For example, depending on the type of data you hold, retention laws may apply. Retention laws generally mandate that you retain information for a specified period of time. If a third party is holding onto that data for you, then you will also need to ensure that the third party is also bound by the retention laws, especially if you don't have the data. Privacy laws are also relevant. For example, if the third party suffers a data breach involving your personal data that you are responsible for, you may need to report it to your jurisdiction's privacy commissioner or data protection authority. If so, you need to know when such a breach occurs, and so you would contractually bind the third party to report to you when such a breach happens. Now, it's important to note, privacy laws are developing and getting more and more complicated, and each jurisdiction is beginning to pass their own comprehensive laws. It's important to stay up to date with the latest privacy developments, especially as big fines may be involved, but that's what I'm here for. In addition, you may also need to think of ethical obligations if you are in a profession such as law, medicine, or dentistry, or accounting, right? You will have privacy laws that you may need to ethically abide to. Outside of these laws, there are also cybersecurity laws, which focus on the implementation of security controls. Generally speaking, privacy laws mandate that you protect personal data. However, other laws may also apply. This brings us to our final question. Should you have a data protection agreement? Unfortunately, it's another. It depends. It depends on what data you are providing to the third party. It depends on whether there are any legal or ethical obligations on you, and whether you need to ensure that the third party remains accountable to you. And it also depends on how important is that data to you and your business. If you need any guidance on this issue, or if you have any technology, business, privacy, or cybersecurity questions, please don't hesitate to reach out and ask. We are always happy to help.